the proper name of a PO is a notice of preliminary objection, so that we need notice. If they intend to bring a notice in within, let them not throw it within the application, because we shall not have notice, or rather sufficient notice to deal with it. But as be that as it may, let me proceed with our application. As is already indicated, our application is dated 16th of June 2025, the year of the Lord. The substantive prayer sought is prayer B on the face of the application. That prayer is that the respondent before court be remanded at the Langat police station or any other police station within the Republic of Kenya, and the reason being, and this is the justification, that it will enable the applicant herein through the Independent Policing Oversight Authority to continue and conclude investigations in respect of the facts, the basis of the arrest of the respondent. Our application is based on both law and facts. And to be more specific, Articles 24, 29, 49, of the Constitution, and Section 36, capital A, of the Criminal Procedure Code. We will also make references to the decision of the High Court of Kenya at Uhuru, Honorable Justice Joy Ngugi, a judge I hold so highly, in the decision of Sudi Oscar Kichumba versus Republic, and this is Criminal Revision number 208 of 2020. Fundamentally, that decision of the learned Justice Ngugi, as he then was, because he now sits at the Court of Appeal, cites and makes reference to the decision of the High Court of Kenya at Milimani, delivered 4 years before it by the learned Justice Luka Kimaru, as he then was as well, because he equally sits at the Court of Appeal, in Michael Rotich versus Republic. And we preempt that the defense are likely to run away with Michael Rotich, so we are going to hit hard on it before they get a chance. In summary, what we are requesting this court to do is to issue an order for what the Constitution calls detention continuing. So that the respondent remains in custody, that's the common name that we call it custodial orders, for purposes of completion of investigations. Cognizant of the limited jurisdiction of this court under Section 8, subsection 2 of the Magistrates Court Act 2015, our references to Article 29 is only in passing and for purposes of laying basis that every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. Your Honor, in further laying of the basis, that Article 24 of the Constitution allows for limitation of rights under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification, and where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important, as informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joy Ngugi J, as he then was, in Sudi Oscar Kipchumba,
the right of making submissions. We have made our submissions. So that once they have done this, they will surrender this for cross-examination, and they'll have no right. Procedurally, it is the deponent to be put on the dock, and the deponent is cross-examined. The respondent lawyers submit. It's the reverse. And that's why I'm asking, is my old JV abdicating the role?
My answer was just lay the basis so that once the deponent comes to the door, then we can proceed from there. So let me just finish with your basis. I believe it's more or less an open statement.
He has done an opening statement.
Yes,
We literally can be doing an opening statement to lay the basis and counter what has been said, because he's doing actually an opening statement. We'll also be seeking that we also put an opening statement and before the court.
So
That's all.
Sorry, I do not understand the basis of that argument, because we are arguing our application with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts. So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never get off-road. Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joy Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And it says, at paragraph 24, if you permit me to read, so, even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that you are, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest. Now, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests, and without refining or essentializing any. You know, I dare say kizungu kubwa. Having highlighted those two texts, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. You know, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interest, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am also obliged unless there is a question.